What's going on, everybody? I wanted to talk about affirmative defenses. It was shocking to me when I started doing consultations that a lot of people did not know about affirmative defenses. Usually, when I talk to people legally, not legally, but when I'm talking about law, and I say, "Hey, have you raised an affirmative defense?" Most people do not understand, or not most people, but some people don't understand what an affirmative defense is and the power of an affirmative defense. Um, and with that being said, I'm trying to figure out what I'm wearing today. So I'm just going through all my cologne, and I'll probably tell you at the end of the video because I can't figure out what I want to wear. Um, that's a plus about having a lot of bottles and stuff because you can. Uh, Sometimes it's like picking clothes. All right, so I want to talk about this. So I haven't even picked the scent today. Um, but why it's so important to understand how affirmative defenses are used and understand how debt collection, debt deterrence, deterring debt, settling obligations, etc. There's a bigger world out there than most of you guys know, than just hearing stuff like conditional acceptances. Except there's a way bigger world out there. And affirmative defense is a way to deal with stuff like certain civil or criminal actions. And with that being said, go forward with the video. All right, an affirmative defense is a defense in which a defendant introduces evidence which, if found to be credible, will negate criminal liability. Wait, wait. So some of y'all that doing some of these GSA bonds, some of y'all that are doing some of these 1099Cs, some of the y'all that are doing 1099As, you trying to tell me that you're not raising certain affirmative defenses before or after you do these processes that which could negate the civil or criminal liability? Hmm. Sounds very powerful. So when you were training or when you were teaching, so-called gurus were teaching you, this is something that they probably may have left out and some of them may have told you. But when I say so-called gurus, it's not an insult to anybody. Some people may see you as a guru and really all you're just trying to do is provide a service to somebody. Really, that's what everybody's trying to do. Some people have good intent behind what they do, and some people just don't give a damn. That you don't have that with everybody. But yeah, so criminal liability or civil liability. Okay, so an affirmative defense is a strategy. It doesn't have to always be used, but it is a strategy. And I'm going to save a lot of more explanation for my law class. I'm trying to figure out how to do the law class. Like, am I going to just sit there and train people up? Or if I'm just going to do another video and then say, hey, here it is, you digest it. So I might do both because some people learn differently. So I'm trying to keep my products, open to people who want to learn differently, So even if it is proven that the defendant, okay, I'm going to go back because I was yammering. So I'll read it over again. An affirmative defense is a defense in which the defendant introduces evidence which, if found to be credible, will negate the criminal liability or civil liability even if it is proven that the defendant committed the alleged acts. So it's basically telling you that you could be guilty of sin, but if you raise a right affirmative defense, it can neutralize your liability. Okay. Remember, when they're trying you criminally, they're only trying you based off the prima facie evidence that they were seeing that alleged that you did something. Okay, this is very powerful information. This is not light information that I'm telling you. I mean, this information can change convictions prior, post, etc. by understanding law. That's why I teach law because you'll get more out of learning the law than you will remedies. Remedies are cool, but then when you figure out how to use the procedure and implement those remedies, oh, you're untouchable. You're untouchable, and that's what most people don't teach. Okay, the party raising the affirmative defenses has the burden of proof. See how you switch from the defendant to being the plaintiff just by asserting affirmative defenses. Now, you don't technically switch, the title doesn't switch, But now you're saying, okay, here's you can either, I'm not going to tell you how to implement that. I'm going to save that for a private course. But the way that I would implement affirmative defenses, or the way that I would use it would just knock the case out, because you have to understand how to use this. It's very strategy. Remember, court, there's a strategy. Cleaning your credit off, it's a strategy. Life, it's a strategy. If you don't have any strategies, you're failing. You're already failing. If you can't see where your life is going in 5 to 10 years, you're already failing. So I'm going to deviate from this a little bit, and I'm going to go into some more, because I'm going to show you guys a little bit more on this call. Um, but there's some things I want to talk about. So, like, when I'm talking about stuff like you have to plan, you have to be prepared, you have to have a strategy, that teaches you how to think in these situations, not a guru. A guru cannot teach you to think in certain situations. They can give you a ton of information. Like, you can sit down with a lawyer. A lawyer can give you a ton of information, but the lawyer is not going to implement that information for you, especially not for free. Like, unless you're a friend or something, they're not going to implement that information for you, because a lot of this is understanding, and a lot of it is you have to always pick what's best for you. No one can pick it. We can always tell you, we think this is a good suggestion, or this is it. Everybody, that I don't give a damn if they get remedy every time. They're only giving you their opinion. So, with that being said, always have a plan, and do not live too far in the past. Don't live too far in the future. Kind of enjoy the now. You know what I'm saying? So, with that being said, now I'm back. So, raising an affirmative defense does not prevent a party from also raising other defenses. See? So, you can raise a defense, okay? It doesn't have to be an affirmative defense, but you can raise a defense to an action that is being brought against you. And a lot of times you guys don't do that, and you don't know how to properly do it. You don't know how to properly write emotion. You don't know how to properly express an emotion, or get parts of your motion denied, or some of your motion denied, or the whole motion denied, or file a motion where some of it's granted or all of it's granted. Okay, that comes in with knowledge and how to put things together. And a quick way that you can learn is by mirroring what the attorney does to you. Okay, by mirroring what an attorney does will teach you law quicker. You don't need to know everything. That's what a lot of you guys are thinking, that when you get sued or somebody sends a letter in your mail, that you need to know all the remedies. No, you just need to know your options. So as long as you know your options, you're good. Okay. So here's some of the affirmative defenses. Okay. So self-defense, entrapment, insanity, necessity. See, necessity is an affirmative defense. So look, the necessity defense. And a necessity defense is a defense to liability or for unlawful activity where conduct cannot be avoided, and one is justified in a particular conduct because it will prevent the occurrence of harm that is more serious. Don't that sound like that sounds like some stuff that some people can use in criminal law? In criminal law, necessity defense claims that the actor's illegal conduct was necessary, lesser of two evils in a situation threatening specific harm to actors or others. According to California jury instructions, a successful necessity defense must prove. See, when you start going through these defenses, you can see what you need to prove, and this will help you structure a motion or an affidavit in a format that complies with those states' regulations and requirements, because you can look it up in state law. Now, some people, they say, "Oh, I ain't giving legal," but I don't give a damn. Okay, like people, man, stand on what you say. You know what I'm saying? Stop trying to absolve yourself of liability of what you say. You said it, stand on it. I don't have to give you no disclosure. This is what it is. I'm just reading to you. You see what I'm saying? What you do with the information, that's on you. All right. So, under federal rules of procedure, Rule 56. Here we go to that thing doing it again. I don't know why it does it, but I'm gonna have to turn that off. Go in there. Okay, under Rule 56, Any party may make a motion for summary judgment on an affirmative defense. So you guys didn't know that you can do a motion for summary judgment if your affirmative defense is proper. So that means if you did an administrative process and your administrative process creates an affirmative defense, you can use it to stop the civil or criminal liability. Did you know that? And may I ask why you were not told that? I try to tell this to people, but no one ever listens when I tell them that all you have to do is use your affirmative defense or use your administrative process and set it up to prove one of these affirmative defenses, and you can get rid of civil liability and criminal liability. It's just how how you use it. Okay, and I'm going to show you something. I'm not going to show you everything I have to say. I'm not stupid, but I'm going to show you something. Okay, there's some dispute as to whether certain defenses are actual affirmative defenses or just standard defenses. So remember, there is a standard defense and there's an affirmative defense. Just on this video, we're going over affirmative defenses, and then I will go over standard defenses and how they apply when you use those in them. Okay. All right. So this is from Fair Use of an Affirmative Defense. So this is a publication. All right. So it says the Supreme Court's decision in Campbell versus a Cuff Rose Music Inc. solidified the treatment of fair use of an affirmative defense. However, see, this is why I don't read case law tough like that. I do read case law. Don't get it twisted. I read case law. But what case law is there to do is to make it clear. It's not to make a set authority, okay, unless it's down from the Supreme Court. But really what it is to make unclear things clear. That's why I said what I said about right to travel. I said, why are you still making this argument when it's solidified? Then you need to argue what rights were abridged. So then what you're trying to do is get it to where those rights can be solidified for other people. You see what I'm saying? But you can't do that if you keep bringing up the same arguments. You see what I'm saying? You have to bring up different types of arguments because that's how other people get saved, by your actions. You see? So, however, treating fair use of an affirmative defense shifts the burden to the defendant. Okay. So what happens is they have their prima facie evidence that they filed on the case on you, right? But you don't have any contrary evidence. And there's ways to bring in contrary evidence. And a lot of times people don't do that. And when you don't do that, then what the court is doing is going strictly off their complaint and granting them a judgment. And you're like, oh, the court is evil, and so and so is evil, and they don't listen to me, and all because you're not following the rules. You're not looking up when you file certain things. How is this supposed to be put in the court? How am I supposed to file this? How do I get a hearing date? How do I do all of this? These are the questions you need to ask yourself, and that's why I'm saying it in the video because I'm trying to show y'all love for all the support that y'all give my channel. So now you understand when you get to court, like, oh, this is a thinking game. This is not a paperwork game. This is not I'm a bank, I'm over you game. This is not I'm a judge. It's a thinking game. Okay. That's why I love it so much. That's why I love learning the law. That's why I love this so much because it's a thinking game. I'll never run out of knowledge in this game. I'll never know too much. I'm always going to be searching for more knowledge. That's the beautiful thing for y'all that are on this path. You're on your right path, even if you're getting remedy or not. You're still on your right path because you went from a person who probably watched television all day, never paid attention to what was going on in your life, and now you're being more focused on what's going on in your life, and you're going to have the ability to take control of it. Okay. While in most fair use cases, plaintiffs are able to prove are able to easily prove a prima facie case of infringement. So they're saying, okay, basically, due to the evidence that is presented to the court, this is a pretty easy case to prove because of the evidence and your actions. So then you have to see what cause of action that they're saying that you did, and then if you did something illegal, you have to say, well, this is my justification for doing that. I know people, I don't want to do all that. I just want to go in there and I just want to blah, blah, blah. Fam, you got to play by, okay, I can't go on a basketball court and then start playing with football rules. I can't go on a golf course and then start playing football. Come on, man. Like, y'all just want everything so easy, man. It's not easy. It takes time to learn this stuff. If it was easy, everybody would be doing it. You would see everybody riding around in Bentleys. So much it would drive the price of Bentleys to be nothing. So all of this takes time. Be patient. All right. So this article identifies that despite its decision in Campbell, the Supreme Court has not yet undertaken a thorough analysis of whether Congress intended fair use as a codified in Section 107 of the Copyright Act to be treated as an affirmative defense. In fact, as explored in this article, the legislative history cuts against viewing fair use as an affirmative defense. And the legislative history explicitly confirms what the statute clearly states. See, that's really what a lot of these cases are to do, is to tie the line up from uncertainty or unclarity to clarity. Like, most of us really should not be in court because a lot of this stuff is already decided. We should be going straight to settlement. That's why most judges are trying to push people to settlement, because they're like, dude, it's already pre-decided. We already got enough case law to support your idea or somebody else's idea. You see what I'm saying? This is not some meritorious argument that's going to change the world. Okay. So a defense, yes, but not an affirmative defense. The negative consequences of labeling fair use and affirmative defense support shifting back to what Congress intended. Fair use should not be seen as an affirmative defense, but should instead be treated as a defense that shapes the scope of copyright owners' rights. Okay. So like a lot of these law reviews are really good. You get to learn a lot. Like so like you might hear me, and a long time ago I did a video talking about attorneys and why you don't need them. But there are good attorneys that actually break this law down and make it for the layman. They bring it to the layman. Somebody brought up Matthew Widener. Shout out to Matthew Widener. He has a law channel. He knows me as a I used to be his he used to be opposing counsel against my firm. Yeah, like Matt Widener over there. He has some good information too. He's an attorney, I think, out of St. Pete area, Florida. But he'll remember him. All right, so let's see. Affirmative defenses. All right, this is from a legal review, so I had to sign up for it because I wanted to make sure that you guys got this work as they say. So you guys are learning the law from this channel. I want to be some type of beacon for teaching you some process, but not really going into like processes. You see what I'm saying? If you learn the law aspect of it, I'm trying to make it so a person that may have an eviction in a week or so could do something, opposed to making this so complicated and putting people all over the place. That's what I'm trying to do. So like, I'm not trying to enable the person that lives at that pace, but I'm trying to at least give everybody a chance to fight. All right, so affirmative defenses. Once a complaint has been filed, a defendant must decide how to respond to the allegations. See? So when somebody files a complaint, don't panic. You just wait, figure out your strategy, put a strategy together, and stand on that strategy. But you make sure that the strategy is a strategy that you could win off of. Okay? C, responsive pleadings and motions page. Affirmative defenses are one aspect of that response. So that's just saying it's one. So I don't have to raise an affirmative defense. I can raise a defense. So it's just like I always tell you guys that the courtroom and the streets are no different. The boardroom and the streets are no different. If you wouldn't let somebody smack you in the face in the streets, don't let them smack you in the face with a suit on in the courtroom. All right, an affirmative defense is a legal defense to a claim which, if supported by evidence, may defeat the claim in its entirety. See, while you're sending letters, what are your letters? They're your evidence. Even if the allegations in the complaint are true. So you can actually say, I didn't pay my mortgage, and this is why I didn't pay my mortgage. And I sent numerous letters to my mortgage company letting them know that this is invalid and that they failed to listen to me. And now we're in court. And I should receive punitive damages because they got notice and they still didn't rectify the issue. Ooh, did he say that? Yes, he did. See, point of law, POL, court opinions. See, remember, case law is nothing more than court opinions. So all these people reading all this case law is going to keep you all over the place. That's why you have people telling you that money of accounting is not money, but it's still called money of accounting. Gold and silver, fam, is a form of money. It's not the only form of money on the planet. All right. So we gotta use common sense because Article 1, Section 10 does not say that gold and silver is money. It says that no state, but you don't deal with the state Wisconsin, you deal with the state of Wisconsin. So they are well within their means to ask you to pay in any coin of currency that is accepted. And the coin of currency of today's flavor is negotiable instruments, money of exchange. All right. This is in contrast to a defense that denies the elements of the allegation. A defendant bears the burden of proof, bears the burden of proving an affirmative defense. See? So if you raise an affirmative defense, you need to attach exhibits to prove your affirmative defense. Okay? So when to plead an affirmative, they even go that far to tell you when to do it. So when people tell me I can't figure this stuff out, you're not applying yourself, dog. You're not applying yourself. That's what it is. I'm not saying that to belittle, besmirch, or harm anybody. But how could you be planning it? How could you be doing that when it's so easy to find this information? You have the Library of Alexander to tip your fingers. Use it wisely. I remember back in the day when the internet wasn't nothing but cat videos and porn. And now you got all this on the internet. And now you got all this stuff that'll teach you what you want to know. You see? Take it back to the 70s. You dig, Jive Turkey? All right. So affirmative defenses must be timely filed. This is what people don't get. Court is about timeliness, dog. It is not about what you think it is. Some of y'all, the reason why it's hard to get rid of your mortgages, why it's hard to win cases, because you do not understand that they are time. It have to be timely filed. That means that if a judge grants an order, there is a certain time frame in that state or county that you have to object to that order. And some of you guys don't, and that's how they take your house. In the pleadings, or the right to assert them may be waived. What? Affirmative defenses must be timely filed in the pleadings, or the right to assert them may be waived. You can't make that up. Come on, man. So when people are telling me I don't know law, I don't understand it, what I'm telling you is going to get you, I'm using their law. I'm literally using their law. I've not told you anything to get you locked up. Come on, man. Stop. Put some more respect on this channel, man. It's a lot of disrespect. Pre-answer, motion to dismiss. If the defendant elects to file a pre-answer motion to dismiss, affirmative defenses may be raised at that point. Wow. Listen to this. I don't even know if I should make this a public. I should make this private. If the allegations in the complaint on their face show that an affirmative defense bars recovery on the claim, the complainant can be subject to dismissal under Federal Rules of Civil Procedure 12B6, POL, court opinion. Okay. For example, a statute of limitation defense can be raised by a motion to dismiss if the running or expiration of the statute apparent on the face of the complaint, POL, see overview responding to the complaint. Okay, so then I tell you, answer. If not pled in a pre-answer motion, see, you can file a pre-answer motion. A defendant should plead all, I'm sorry, a defendant should plead all applicable affirmative defenses in its answer to the complaint to avoid potential arguments of waiver by the plaintiff. Okay. Some courts find that failing to plead an affirmative defense is the answer. In the answer results in the waiver of that defense. Thus, it is better to raise relevant affirmative defenses at the first opportunity. Well, they're not telling you the truth. Let me explain something to you. A court is a debt collection, okay? And I'm telling you why I said that when you go to court, they gave it's really a new debt. What they did is they took the initial principal from your the older debt, and then they add fees and stuff to it. So that's what I'm saying. It's a new debt. It's not the same debt. You know what I'm saying? It's the same principle, but it's not the same debt because everybody's trying to make money off of you. The court's trying to make money off of you, and the attorney is trying to make money off of you. So for somebody to say I was wrong saying that, they really don't understand what's going on. All right. So how it's telling you how to raise this. This is why I try to tell y'all, like, if you really want to learn something, you'll find a way. If you kind of want to learn something, you'll find an excuse. Look, how to raise an affirmative defense. Okay. So under Federal Rules of Civil Procedure 8C, so they telling you this is basically a guide. So I'm definitely gonna copy this because I had to. I think I gotta pay for this if I don't, but I'm gonna copy it anyway. So under Federal Rules of Civil Procedure 8C, a defendant must affirmatively state any avoidance or affirmative defense when responding to a pleading. See, they ain't say responding to the complaint. They said responding to a pleading. So if somebody makes a pleading, I could do an affirmative defense just to that pleading and lock them into just arguing on their pleadings. That's why a lot of lawyers will tell you you don't want to go to court. It can get very lengthy because we can argue about everything. We can just stay in court and just waste the damn court's time until the judge is like, enough. That's why the judge is there as an arbitrator. The person who's running the show is the clerk, not the judge. And y'all sitting here trying to yell at the judge. What tribunal I'm being tried under? Is it criminal? Is it civil? The court gives you an admiralty in a common law jurisdiction. No, it doesn't. But that's why I said that. And for y'all, I'm not insulting you. Yusuf didn't make that up. People thinking I'm talking about again. No, man, I got love for Yusuf and them over high frequency radio. If it wasn't for Yusuf, I wouldn't have learned a lot of this shit. Keep it 100. So I was watching when I saw high frequency radio. I was already studying this stuff, and I was like, oh man, he got the Kabbalah. He got all this stuff on here. So y'all don't see the old high frequency. So I will never diss. I'm not on here dissing people. We're not doing that. I'm not gonna sit here and talk about somebody else's process and go, it's people selling you all the affirmative, the birth certificate stuff. I know that's trash, but it's not my job to go after each person that teaches that. That's not my job. My job is to stay on my path, and the people who are staying on their path with me, we're gonna go to the same place. So it is what it is. The purpose of requiring the defendant to plead available affirmative defenses in its answer is to provide the plaintiff with notice and opportunity to discriminate. I said discriminate. Uh, to demonstrate why the affirmative defense should not succeed. You see what I'm saying? You can flip the game on these people just by knowing what to do. That's why knowledge is worth more than procedure. Because when you keep paying for these procedures, the people are not going to tell you what you need to do when you need to get into litigation. And that's where it gets very expensive. That's why I tell people it's better to know what to do in court first and then double back to this discharge information. Because if you do something and it doesn't work, at least you're confident and comfortable about going in court and suing somebody just in case you have to. A defendant should take care to properly designate defenses and counterclaims. However, so basically, you don't even need You don't even need to be an attorney. You just need to have common sense. You see what I'm saying? Like, if somebody is suing me, I need to see, well, what do I need to disprove what they're doing? What do I need to extinguish their claim? If they're saying I didn't tender payment, okay, let me go tender payment. Okay, now what we talking about? You're the one in the court case holding all the power, and you're just not thinking. And that's why this channel is here. It's here to make you think. It's not here to give you the answer. Once you start thinking, you will come up with the answer. All right. However, if a party mistakenly designates a counterclaim as a defense or vice versa, the court must, if justice requires, treat the pleading as though it was correctly designated and impose the terms for doing so. So, what they're telling you, as even if you file something and it's not correct, the court is going to act as if it's correct, and they're going to handle it as such. So they're basically saying that you don't have to write, it doesn't have to be perfect. Okay. So we're going to go on some of the 18 defenses. All right. So federal rules, man, I might just keep, nah, man, I ain't finna do all that. But yeah, I don't know where I got this publication. This publication is fire. I'm about to get into it. But yeah, I wanted you guys to understand affirmative defenses, and because it's so powerful for you guys to understand that. And with that being said, I'm just gonna sign off, and I still haven't picked out a clone, but deuces.